We thank you so much for watching Voices of the Bar, where the legal world speaks. We are going to break down the burden of proof with cases. We break down standard of proof with cases. We also break down legal principle of legality. We include cases and articles in there. And then that will be the end of this video. So let's begin with burden of proof. One, students should know that Article 23, clause 3 is the one that talks about burden of proof. So there is no way you discuss this principle and you don't bring out Article 23, 3. And remember, if you are quoting anything, the Constitution should be the first thing you quote before you bring the Acts of Parliament, before you bring your penal code, before you bring your evidence act and very many other acts of parliament. The first thing you quote is the Constitution, because it is the supreme law of the land. Then after you have discussed Article 23.3, you now bring any act of parliament. If you have, for example, 101 under Evidence Act talks about burden of proof. But now let's go to the legal meaning of burden of proof. That this word burden of proof means that. Let me give you an expression first. That there is someone who has committed a crime. When that someone commits a crime, they're accused. That crime which has been committed against someone, the victim. Now, that somebody who the crime has been committed against is under duty to bring some sort of evidence to prove that indeed there was a crime which has been committed against me. So you bring evidence. So that evidence is what we call the burden of proof. That because you have alleged, he who alleges must prove. Because you have alleged that there is a crime which was committed against you, so bring some sort of evidence. Now, that evidence is what we are calling burden of proof. Now, when we go back to the case we have been discussing many times here, Wilmington versus DPPP, that case only brought the principle, set the principle of burden of proof. It is not a case you are going to use to explain the meaning of burden of proof. That case only established the principle. Now, when you bring evidence, there must be a standard we subject that evidence to. And now that standard is what they call beyond reasonable doubt. That this evidence you have brought, you must prove it beyond reasonable doubt. You must leave no stone unturned. You must prove to the extent that everybody in court, the judges and everyone else, says that yes, indeed, there was a crime committed, and indeed, it is the accused who actually committed this crime. So that is what we mean by standard, beyond reasonable doubt. The standard. You don't just bring evidence. Let's take an example. In civil cases. In civil cases, you are supposed to prove on balance of probability. The person reporting should just be more slightly convincing on preponderance of evidence, balance of probability. But in criminal matters, we prove beyond reasonable doubt. The question is, why is the standard beyond reasonable doubt? You now write and tell the examiner that the standard is beyond reasonable doubt simply because there are many reasons, but I'll pick this one. Simply because in criminal law, we award the punishment, heavy punishment. Somebody is going to be sentenced to death, life imprisonment, 100 years in prison. So you don't just have to prove on balance of probability. You prove beyond reasonable doubt. You must get this person who committed the crime, and you prove to court it is him, such that the punishment that is given to him is the rightful punishment. So that's why you need to prove beyond reasonable doubt. That is the standard. Now, the case of Wilmington is the one that established this principle. If you remember that case very well, Wilmington was first convicted in the court of first instance. But when he went in the House of Lords, they reversed the decision and said that in criminal matters, the burden lies on prosecution to prove beyond reasonable doubt. So you cannot discuss standard of proof and the burden of proof, and you don't say that the case of Wilmington versus DPP established the golden thread principle that the burden in criminal matters lies on prosecution to prove beyond reasonable doubt. Now that you have established, you have given the examiner that the Wilmington case established the principle that burden lies on prosecution to prove beyond reasonable doubt, you now discuss other cases where the principle in Wilmington was applied. Let's take an example. Then you say, for example, in the case of Uganda versus Dr. Mafichirabo, who was accused of killing a girlfriend, prosecution proved beyond reasonable doubt that yes, it was Dr. Mafichirabo who had killed his wife, and he was convicted. Let me give you a trick. All criminal cases where the accused has been convicted, it means that prosecution proved beyond reasonable doubt. All criminal cases where the accused has not been convicted, it means that prosecution failed to prove beyond reasonable doubt. So that is how you're supposed to discuss burden of proof and standard of proof. You give both sides. You give a case where the principle which was established in Wilmington was applied and it succeeded, and where it was applied and it never succeeded. Let me give you a case where it failed. In the case of Uganda versus Dr. Agrechiinj, who was alleged, it was alleged that he had killed his wife, but he pleaded the defense of alibi, and prosecution failed to place him at the scene of crime, and therefore he was not convicted. He was acquitted. So when discussing these principles, you must show both sides. Of course, where the accused has been convicted, it means that the burden lied on prosecution to produce evidence, which they brought, and they also proved their evidence on the standard beyond reasonable doubt. I hope we are clear with burden and standard. So now let's cross to principle of legality. We ask you to subscribe, to share, and like our videos. Don't watch minus subscribing. Please, please, please subscribe. So now, colleagues, let's cross to principle of legality. The principle of legality sine powena sine lege, sine crimine powena sine lege. Those Latin markings, but because they mean no crime minus no punishment without crime. The Latin markings you can read. Let's focus on the law now. This principle is clearly established under Article 28, Clause 7 of the Constitution. So when discussing principle of legality, begin by quoting Article 228, Clause 7. Actually, if you want to discuss the principle of legality, Article 28, Clause 7, 8, 9, 10, 11, 12. They are the articles discussing the principle of legality. Now, what we mean by legality will take 4 stages, 4 elements, which we are going to attach a case on every element, and also a case or an article. 1, pre-existence. 2, the law should be clear. 3, limit on interpretation. 4, retrospective application of the law. Therefore, I'll repeat: pre-existence, the law must be clear. Limits on interpretation and retrospective application. So, let's begin by pre-existence. The principle of legality seems to suggest that before you were convicted, before you were taken anywhere, the crime you have committed should have existed. That no one should be subjected to criminal proceedings when the crime they have committed has never existed. The crime should first exist. So meaning that where you commit a crime and it is not gazetted, it is not in the penal code, it does not exist, nothing happens to you. I'll give an example. There is one university, we were told that a student copied in the exam, but the way he copied, of course, he was gotten. They went to the DC, they displayed all the copying styles, wanting to award him a punishment depending on what he had copied. When they scanned through, the way he had copied was not captured, and he was left because the crime did not exist. So that is why when you are arrested, they say which crime has which crime. They say under the penal code this crime it should, where it is not there, you are left to go. So that's principle of legality, that no one should be punished if for a crime when committed, at the time when it was committed, it did not exist. Article 28, Clause 7 explains this. Homosexuality became a law the other day. What does it mean? That those who committed homosexuality before it became an offense in Uganda have no crime. There is no crime. Pre-existence of the law. It should have existed. But if at the time when you committed it, it was not in existence, no business. Use Article 28, Clause 7 to explain to existence. Let's go to the law must be clear. The law should be clear. Colleagues, the law should be clear and easily understandable to everybody. It should not contradict. Let's take an example. Look at the case of Andrew Mwenda and another versus AG. There were two offenses in the penal code: seditious intention and seditious offense. Section 39(1)(a) and section 41(b). These offenses meant that no one should encroach on the peace of the president. You understand? No one should disturb the peace of the president. You don't talk about the president of Uganda just like that. When Andrew Mwenda and another committed the crimes of seditious offense and seditious intention, they were taken to court. Court observed that that law was not clear. How? Because Article 29 of the Constitution gave people freedom of expression. Again, you are saying no one should disturb the peace of the president. So how will somebody express themselves? So they found that the other law was not clear. It was contradicting the Constitution. And remember Article 2.2 of the Constitution. Any law or custom which is inconsistent with the provisions of this Constitution, that other law or custom to the level of this inconsistent shall be void. So seditious intention and offense were scrapped off because they were contradicting the Constitution. If you say I have freedom of expression, why do you say again I should not talk about certain things? Expression is expression. So the law must be clear. That way, the offense of seditious intention and offense were not clear. And they were scrapped off. So the law should be clear. Where you see you can't understand the law, there is a problem. Okay? So you use Andrew Mwenda there. Let's go to 4. 3. Interpretation. Limits on interpretation. The law should be clearly interpreted and easy to interpret. And when you interpret it, you are able to know what you have interpreted. Look at the case of Salvatore Aboki versus AG. This is a case about witchcraft. Salvatore Aboki versus AG. In the case of Salvatore, the question was, is Section 3 of the Witchcraft Act constitutional? Because they were saying, being with a spear, a backcloth, beads, it meant that you were witchcraft. And that was not the point. So, court observed that on interpretation of the law, it should be clear and easily understandable. So, court did not agree on what amounted to witchcraft, and Section 3 of the Witchcraft Act was scrapped off. Because you can't say that if you have a spear, you're a witchcraft. Maybe I'm a hunter. That's the whole point. Okay? So it should be clear. When we interpret the law, it should be clear. Let's go to 4. Retrospective application. We are saying that the law does not work in a backward mode. We remind you to subscribe. Subscribe, please. The law does not work in a backward mode. You can't say that now we have the law. Let us look for everybody who committed a crime before the law was made and we arrest them. No. The law works moving forward. Take a good example of homosexuality. Now the law has passed. We cannot say that those who committed homosexuality before the law, you come, we arrest you. We cannot. The law does not operate in a backward mode. The law moves forward. So you explain what each one of them mean. You put a case. After putting a case, you put an article, and then you go. So we thank you so much for watching Voices of the Bar, where the legal world speaks. Subscribe, share, like our videos.